All right, class, welcome. Think of this as your final exam cram session for one of the absolute trickiest topics in all of torts, proximate cause. This is the spot where liability hits a wall, and trust me, by the end of our time here, you're going to know exactly how to tackle it. So, let's just jump right in with a hypothetical. Picture this. You do something negligent, a minor fender bender, let's say. But then, something totally bizarre happens. A lightning strike, a random stampede, a criminal pops out of nowhere. Where does your legal responsibility actually end? I mean, really, that's the multi-million-dollar question of proximate cause, and today we are going to nail down the answer.
Here's our game plan. First, we'll nail down what proximate cause even is. Then, we'll get into the main legal test courts use. This is the big one. We'll look at what happens when that test fails, and of course, we'll walk through some absolute classic cases. Stick with me, and you'll have the exact framework you need to ace this part of your exam.
Okay, let's start at the beginning. Proximate cause. Now, you remember the 4 elements of negligence, right? Duty, breach, causation, and damages. Well, that causation piece, it's actually got 2 parts. After a plaintiff proves the defendant was the cause in fact, the but-for cause, they hit this final and honestly much tougher hurdle, proximate cause.
So what is it really? Proximate cause, or what some people call legal cause, is basically a policy decision. It's the law's way of drawing a line in the sand and saying, look, even if your action technically caused this injury, we're not going to hold you liable for every single thing that happens afterward forever. That line gets drawn at what falls within the foreseeable scope of the risk you created.
Probably the easiest way to get your head around this is to think of it like a chain. The defendant's negligent act, that's the very first link. Every event that follows is another link. So the whole legal question becomes, at what point does something so weird, so out of left field happen that it literally breaks the chain?
And that brings us to this term, an intervening force. This is some new event that jumps into the story after the defendant was negligent. It could be another driver messing up, an act of God, or even a crime. Now, an intervening force makes the chain more complicated for sure, but, and this is so important, it doesn't automatically break it.
So how in the world do courts decide if the chain holds or breaks? Well, they use a crucial tool called the Foreseeability Test. This right here is the heart of our entire discussion today.
Let's start with a case where the chain of causation held up like a champ, even with some unbelievably wild facts. Let's talk about Derderian versus Felix Contracting. This case is the textbook example of foreseeability keeping a defendant on the hook for damages.
Just check out these facts. You've got a contractor, Felix, who doesn't properly secure a work site. Then, a driver has an epileptic seizure, loses control of his car, plows through the flimsy barricade, hits a worker, and knocks over a kettle of boiling hot enamel that splashes all over him, literally engulfing him in a fireball. I mean, it sounds like a 1 in a billion freak accident, right? So the court had to ask, is the contractor still liable for this insane sequence of events?
And the court said, yes, absolutely. This case just perfectly lays out the rule. The court's reasoning was that the whole reason you're legally required to put up a strong barrier at a construction site is precisely to protect workers from traffic. The risk of a car coming into the site is the very thing that makes the contractor's failure negligent in the first place.
So here's the key takeaway. This is the black-letter rule you need to highlight in your notes. Felix, the contractor, didn't need to foresee the epileptic seizure or the boiling kettle. All they needed to foresee was the general risk that a car might, for any number of reasons, enter the worksite and hurt somebody. And since that was foreseeable, the chain of causation was still intact. Remember that for the final.
Okay, so we've seen when the chain holds strong. Now let's flip it around. What does it take for an intervening force to be so unforeseeable that it actually does break that chain of liability?
Well, that's what we call a superseding force. It's an intervening force that's so, and these are the magic words, highly improbable and extraordinary that the law decides it's just not fair anymore to hold the original person responsible. The chain is officially broken.
And to see this in action, let's look at another famous case, Ventricelli versus Kinney System Rent-A-Car. This one gives us the perfect contrast to Derderian. In Ventricelli, the facts were totally different. The defendant rented out a car that had a faulty trunk that kept popping open. The plaintiff, the driver, pulls into a legal parking spot to try to close it. And while he's standing there, a totally different parked car suddenly lurches forward out of nowhere and hits him. The court said the rental company was not liable. And you gotta ask, why? Well, think about the risk.
The risk created by a faulty trunk is, inconvenience. Maybe your groceries fall out. It is not the risk of being hit by a completely separate, randomly accelerating parked car. That event was so unforeseeable, it snapped the causal chain.
Okay, let's add another layer of difficulty here. What happens when the intervening force isn't an accident, but an intentional or even a criminal act? Now, courts are often way more likely to call these superseding, but not always.
So in Metcalf vs. Washington Heights, a condo's intercom system was broken. This forced a guest to wait outside where she was tragically assaulted. The court ruled that the assault was a superseding cause. Why? The risk of a broken intercom is being annoyed, getting rained on, maybe being late. It's not creating the conditions for a violent criminal attack. The court said that connection was just too thin, too remote.
But now, contrast that with Delaney v. Reynolds. Here, a police officer allegedly left his loaded gun where his partner, who he knew was depressed and suicidal, could get it. She used that gun to injure herself. In this case, the court said a jury could find the officer liable. What's the difference? Because the very risk that makes leaving a gun around a suicidal person negligent in the first place is the risk that they might use it to harm themselves. The intentional act was, tragically, a foreseeable part of the original negligence.
Okay, deep breath. Let's bring this all home. This right here is your ultimate cheat sheet. This is how you spot these issues and break them down perfectly on an exam.
So when you get a fact pattern with a crazy chain of events, you're going to ask yourself these 3 questions. Number 1, was the general type of harm foreseeable? That's your dirty Aryan question. Number 2, was the intervening act truly extraordinary? That's your Ventricelli question. And number 3, the big one, did the defendant's negligence create the very risk of the harm that actually happened? That is your Delaney question.
This table puts it all right there for you. You've got Ventrelli and Metcalf showing how unforeseeable risks break the chain. You've got Dirty Aryan showing that the precise way it happens doesn't matter, as long as the general risk was foreseeable. And you have Delaney showing that even an intentional act won't break the chain if it's the specific risk the defendant negligently created.
If you remember only one thing from today, let it be this. If the harm that occurs falls within the scope of the original, foreseeable risk, liability keeps going. If the new act is truly extraordinary and unforeseeable, liability gets cut off. It really is that simple.
And that brings us to the final thought. Proximate cause is a tool, a public policy tool, meant to create fair, manageable limits on who has to pay for what. But as you've just seen, it can lead to some results that might feel a little strange. So the question to ponder is this. Does this legal line, drawn in the name of foreseeability, always match up with our gut sense of justice? Something to think about. All right, class dismissed.